Good morning, sir. Are you Matthew Shane Wadsworth? And Mr. Wadsworth, in cause number 24, DCCR 1286, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon. That's from May 4th of 2024. It's my understanding that the District Attorney's Office has either already or plans to file notice that you have at least one prior felony offense conviction. If that's true, that you have a prior felony that's not a state jail, a regular felony, then what that means, if you go to trial, your punishment could be enhanced to that of a first-degree felony, which is between 5 years and up to 99 years or life in prison. Do you understand? You don't? What do you not understand? You don't understand any of it? Okay. You've got to understand some of it.
I'm sorry.
What? Go ahead. What you were going to say?
Just extensive MHMRA history, and I don't believe that any of this is even really happening.
Well, it is happening. You're here and you're charged with aggravated assault with a deadly weapon. Do you understand that you're charged with it? I'm not saying you did it. I'm saying that's what you're charged with.
I'm sorry, babe. I just really don't understand how.
You don't understand how you're charged with it? So the district attorney's office, there was a case filed. They took it to the grand jury. Grand jury said they think there's enough evidence that you intentionally or knowingly or recklessly caused bodily injury to Merlin Richard by striking Merlin Richard in the head with a bat. That's what you're charged with. Do you understand that? Do you understand that? You don't have to like it. You don't have to agree with it. I just need to know if you understand it. I mean, you're here saying today.
Somebody's saying that I hit them with a bat.
Mm-hmm.
Okay, I understand that somebody's saying that.
Right. So you understand that somebody said that you hit them with a bat, and so charges were filed. You're saying, through Mr. Rojas and what I've received here on my computer, that you didn't do that, and you want to have a trial and let a jury decide whether or not that person's telling the truth or not if you did that. Is that all correct? You understand that? And there's no okay, I guess.
Sorry.
I need to know that you understand before I set your case for trial, what you're charged with, what someone is saying that you did.
Okay, I understand somebody's saying this thing.
Okay. And the district attorney's office has made an offer, if you wanted to plead guilty and say, yeah, I did do that, for a 5-year term in prison. But I have here on the computer something that you've signed with Mr. Rojas that says you don't want to take that 5 years, that you don't agree that you did that to someone, and you want to have a jury trial. Is that what you want to do? Well, that's not the question that I asked you.
I'm sorry, ma'am. Say it one more time.
The question that I asked you is, there's an offer of 5 years in prison if you agreed that you did this and you wanted to plead guilty.
I understand you now.
Okay, but I have something here that says you don't want to take that offer, that you want to plead not guilty and let a jury decide whether or not you did this or not. Is that correct?
Yes, ma'am.
Okay. Mr. Rojas, have you had issues like this?
Judge, no, ma'am.
Okay. All right. Then what I'm going to do, Mr. Wadsworth, is place your case on the trial docket, and we'll get it ready for trial. Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right. Then Mr. Rojas will remain your attorney, and he will begin preparation for trial. All right. You can go back with the bailiff. James Lofton. All right, sir, did you get someone hired?
Not yet. I've been waiting to get a hold of Tom Kelly. I called their office several times and talked to Mr. Langston this morning to feed him the business for last time.
Okay, why are you just talking to him right now?
I've been trying to get a hold of Mr. Kelly. I called his office. I don't know if they called me back or not. It was from my work schedule. Like my phone don't work.
So here's the thing, Mr. Lofton, you're out on a bond for an MTRP, and I'm pretty sure I told you last time you needed to get someone hired.
This one. I'm calling, I'm doing my best.
Well, it doesn't sound like you are if you just, you're not sure if he called you back or if you left him, you need to call, hang on, don't talk over me. All right? You're on probation for a serious offense. The allegations are that you violated your probation. The fact that you got a bond on that is better than what some people have. You need to get a lawyer hired before the next court date. All right? If you're working, then you should be able to afford to get a lawyer. You're going to have to take a day off. You're going to have to do whatever it takes. This has to be a priority. If you don't have a lawyer and you don't talk to at least 3 lawyers and bring me proof of that when you come back, then your bond will be raised and you'll be back in jail next time. Do you understand? All right, step in front of the clerk. Ms. Perazzo, you have Camden Jackson set for a bond hearing. Oh.
Yes, that's correct.
And are you hired on that?
Yes, ma'am.
Okay.
I'm gonna pass on that on the bottom.
It wasn't going to go well
I
anyway.
didn't think so. I didn't.
I mean, not that I'm prejudging or anything, but I have lots of circles and marks and things that we're going to talk about anyway
Yes,
right now. Good morning. Are you Camden Jackson? And Mr. Jackson, in cause number 25 DCCR 0114, you're charged with engaging in organized criminal activity. Ms. Perazzo has filed a motion to withdraw as your attorney. And so do you have any opposition to me allowing her to withdraw? Answer out loud. Okay. So Ms. Perazzo, I will grant your motion. Mr. Jackson, do you have the funds to hire an attorney?
She's working on it.
You're working on it? So here's what I'm going to do in the meantime because you're in custody. I'm going to go ahead and appoint an attorney. That way you have no lull in representation. Somebody will begin working on your case. If you get someone hired, then they can file the appropriate motions to step in, okay? But you will be appointed an attorney today. Now, before I send you back to the jail, I want to talk to you about this stack of incident reports that I have of how you're behaving in our jail. And I know that one of the things that you wanted Ms. Perazzo to do and that she had filed on your behalf that we're not going to take up today is for me to reduce your bond. And I can assure you nothing's going to happen other than your bond being increased if you continue to act like the little hooligan that you're acting like in our jail. I can't even tell you how angry this makes me. How old are you?
You turned 19.
Just turned 19. Well, let me tell you something. It is time to grow up. Because you and the other little 18, 19, whatever y'all are doing in there, you're never going to get out of jail. You're going to end up in prison, and your life is just going to be just like this. And is that what you want?
No.
It's not, is it? Cussing at the correctional officers, laying in bed because you don't want to get up, staying up late because you know when you get to sleep late? When you're at home because you're not in jail for violating the law. That's when you get to sleep late. That's when you get to make your own decisions. You don't get to make those decisions right now. And I get a report every single time you're acting up. And you're going to keep coming in front of me with another lawyer, and it's the same thing. The DA knows about these, and if you think that's going to make them want to be nice and offer you some great deal on your case, it's not. All it's going to make everybody want to do is something worse to you. So starting today, if you think you want something good to come out of your case and you want some possible good treatment and to get out and to be able to live a life like the rest of us, start proving it starting today in jail. Otherwise, it's not going to happen. Do you understand? All right, go back with the bailiff.
Thank you, Your Honor.
Thank you. Who is his? Do you know who it's going to be? There's a spot for it on this. I couldn't say any of the words I wanted to say. I know. Hooligan's the best I could come up with without saying anything bad today. All right, so are you Howard Celestine? And Ms. Peraza, will your client waive the formal reading of the indictment in each case?
You will, Your Honor.
Mr. Celestine, in cause number 24, DCCR 0919, you're charged with a third-degree felony offense of manufacturing or delivering a controlled substance from January 10th of 2024. That indictment alleges that you were previously convicted of aggravated sexual assault of a child, a first-degree felony, April 13th of 2009. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you did what they charged you with? And is that prior offense true, that prior conviction? The one that I read out, the aggravated sexual assault of a child, is that true, that is a prior conviction of yours?
Yes.
Okay. And cause number 24, DCCR 1549, it says count one only, but then it says a 20-year term, so it has to be count one and
That's
two.
right, that was my intent.
If it's
That's
20,
correct.
count one and two.
Yes.
Okay.
Oh,
There's only one prior.
right.
So that's what makes that third degree turn into a
The
second.
second degree. Okay. Sorry.
So pleading on count one would only be to the underlying offense.
Right.
Okay, so in 24 DCCR 1549, you're charged with a second degree felony offense of aggravated assault with a deadly weapon from June 24th of 2024. The indictment alleges that same prior conviction from April 13th of 2009. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And again, is that prior conviction true? And did you enter your plea of guilty in this case freely and voluntarily?
Yes, Judge.
And because you actually did what they've charged you with?
Yes.
So in cause number 24 DCCR 1550, you're charged with a first-degree felony offense of murder from June 24th of 2024, and the state's elected to proceed on that count only. And how do you plead to that charge?
Yes.
Again, are you pleading guilty freely and voluntarily?
Freely.
And because you did what they charged you with?
Yes.
In cause number 24 DCCR 1551, you're charged in that case with the state jail felony offense of abandoning or endangering a child from June 24th of 2024. And how do you plead to that charge?
Yes.
Again, are you pleading guilty freely and voluntarily? And because you did what they've charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Peraza?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreements that you've reached with the district attorney, you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Celestine is not competent?
No, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty and true in the cases that you did freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas in each case. In cause number 24 DCCR 0919, find sufficient evidence to find you guilty, and at this time find you guilty of manufacturing or delivering a controlled substance. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24 DCCR 1549, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 50 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24, DCCR 1550, find sufficient evidence to find you guilty, and at this time, or find that you entered your plea freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of the offense of murder, sentence you in accordance with your agreement to a term of 50 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in cause number 24, DCCR 1551, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of abandoning or endangering a child, sentence you in accordance with your agreement to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will all run concurrently, which means together at the same time. I am making an affirmative finding of a deadly weapon in cause number 24, DCCR 1549. I'm handing you in all of your cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Perazzo. All right, good luck to you, sir. You can go back with the bailiff.
And there it is, a story of consequences, choices, and the fragile line between justice and redemption. In this courtroom, we've seen the weight of past mistakes collide with the hope for a better future. The defendant faced the full measure of the law, yet a chance remains, a chance to change, to heal, and to find a path that doesn't repeat the same pain. It's a stark reminder that every action has meaning, and every decision echoes far beyond these walls. What would you do if faced with the same crossroads, when the past and future meet in the balance?